In this section, we're going to talk about dividing the relative retirement interests of the parties in your divorce. So what are retirement interests? Basically, those are the financial plans that are either set up through your employer or ones that the two of you have set up for your own retirement. So the various types of plans, what we want to talk about is first, the ones that are employer related. And there is some terms that you need to know. There are, basically, we're talking about qualified plans now. And when I say qualified, that's a legal term used in federal legislation that basically what had to happen is employees had these retirement accounts and they wanted to divide them as a part of their divorce. And the employers were like, no, we don't want to do that. And generally divorces are only between the two parties. And so they needed to get a court order that would require employers to have to divide up these retirement interests. And so there's federal statutes, and they call them, if it's a qualified plan, basically it says that, yes, employers have the authority to divide up those plans in a divorce. So, and that is important because if you have a qualified plan, you need to get that separate court order. And that separate court order is called a qualified domestic relations order. And I'm going to be talking about it further later on. But I just want you to be aware of that term. So basically, there's two types of qualified plans that are available through your employer. First is the qualified defined contribution plan, which is usually your 401k or your 403b, and those are most common today. And when I say contribution, what it means is you as the employee provided the money, so we know how much money it is. And those are fairly easy to divide up, but it does require that QDRO. But then there are the qualified benefit plan, and those we know as pensions. So the important thing to know about pensions is, as you recall, when you were an employee, your employer said, that's fine, I will go and you work for me for so many years, and then at the end of the time when you retire, I will go and we're going to figure out what your top 5 earning years were, and I'm going to pay you X dollars until you die. And so those are a little hard to value. And so the easiest thing to do when you have pensions, if each party has a pension, maybe you want to just simply say you each keep your pension, because it is really hard to figure out what the value is. And I just want you to be aware of this, that if you don't know what the value is, how do you find out the value? And oftentimes on a pension, the only way you find out the present value of it is to use an actuarial. And that's someone you're going to pay, $400 or $500 to tell you, what is the value now, so that if I look, because you retire, right, generally at 67 years of age, and the date that most people die is 84 years old. So if you're paid, $2,000 over that time period, even though it might be worth, $1 million at the end of that time, you discount it back. And you can see this gets to be it's a formula they use, and most of us don't understand it. So what is a simpler way we can do it? And again, hopefully you're getting the idea that if you're dividing a pension in anything other than each party gets that pension, that you might want to talk to an experienced family law attorney about that, or an actuarial about what the value is. And you also want to be really careful of the language, though, because some parties will say, well, fine, you just get 50% of the value of that pension. But let's say you're 40 years old and you're going to be working for another 15, 20 years or more, and you're getting your divorce now. So you don't want your spouse now to be getting the benefit of you working that additional time. And so that's why you do this qualified domestic relations order, is it said maybe you get 50% of the marital value. So I just wanted you to be aware of the complications of dividing up pensions, and a little lesser, but it's still just as important, dividing up 401ks and 403bs. And the other important point on those is they are pre-tax. And so you need to be keeping that in mind in looking at that division on your asset balance sheet. So another employer account that is not a qualified plan but is available is this SEP IRA. And it just means simple, employee plan. But just understand that those do not need a QDRO. So those are more easily divided up between the parties. Then the plans you set up on your own are generally, some are pre-tax, the simple IRA, and some are post-tax, the Roth IRA. And so you need to be thinking about what are going to be the tax consequences of those. So let's talk about the tax consequences. The only thing I want you to just be aware of is that if it is pre-tax, now if it's a pre-tax 401k and one spouse is going to be receiving a lump sum of that 401k, if they go and they take it as cash, there is going to be a tax consequence, but there's a small carve out in the IRS statute that says, we're not going to penalize you, that 10% penalty if you're under 59 years of age. But there is that tax consequence. One of the things to be careful of is you don't want to, as the spouse receiving that 401k, is to roll it into an IRA and then take it as cash, because now you will pay that penalty. So I just want you to be aware of it. And if you have any questions, that's one where you should be talking to a good tax advisor, someone that knows the law in that area. So one final thing to say about QDROs, qualified domestic relations orders, is that there are only a few attorneys in town that really, handle QDROs a lot. And in our office, we actually have one of our attorneys who handles them. But make sure that you talk to them before finalizing your divorce if a QDRO is going to be necessary, because there is some language that you want to make sure is a part of your divorce. And that's all I need to say about it. But anyway, good luck on property divisions. That's the end of this section.